Protector Busisiwe Mkhwebane has reportedly taken a swipe at a personal cost order issued against her last month by the Constitutional Court. The Sunday Times reported Mkhwebane said she should be granted decisional independence like judges of the courts. She also said that she would not stop doing her work even if it meant she personally paid legal costs when her reports get challenged. Well, Advocate Paul Hoffman from Accountability Now joins us via Skype for a legal perspective on this particular matter. Advocate, thank you very much for waking up with us here on The First Take. First question I want to ask of you is that if the Public Protector says her reports should enjoy the same status as those of judges in courts of law, is that, in fact, correct in law?
No, it's not correct at all. In fact, I think she's got completely lost in the woods. A public protector is an ombudsman-like character. The work that she does is investigative. The work that judges do is adjudicative. They are two completely different functions. The way that the public protector works is in a very limited sphere. She deals with affairs of state and the public administration. She doesn't have jurisdiction over anybody else. And what she should do, but doesn't do, is prepare preliminary reports in which she sets out the remedial action she regards as appropriate when she comes across maladministration or when she is dealing with executive ethics matters across malfeasance. She sets out what she would think is the appropriate remedial action, and she tells those implicated in advance whether or not they have any comment in relation to the remedial action she has in mind. No judge is ever required to do that. Judges don't hold press conferences. They don't speak on Twitter. They don't put videos up on YouTube. And they certainly don't show their judgments to the parties that are implicated in the judgments prior to the judgments being handed down. So for her to suggest that she deserves to be treated like a judge is just nonsensical, and I use that word advisedly in spite of her allergy to it.
Advocate, we all know that the Public Protector at the moment is dealing with credibility issues, if you like. The recent emergence of emails from the CR17 campaign, we know what her report says, that the president may have, in fact, she rules or she recommends that the president has actually misled Parliament and therefore should be sanctioned somehow. Talk to us about what this does for her credibility on this score now that we have an emergence of emails purporting to be from the CR17 campaign. Yes, of course, we don't have any authentication yet from the CR17 campaign managers, but there doesn't seem to be any dismissal of these emails just yet.
Yes, well, you're asking me about the credibility of our current public protector, and I'm afraid it has been shot to pieces in the most spectacular manner by the Constitutional Court this day 2 weeks ago, when it was found that she has, in effect, defeated the ends of justice and committed perjury in the way in which she opposed the Reserve Bank's review of her remedial action, which required Parliament to revise the Constitution in relation to the workings of the Reserve Bank. And at the moment, her credibility is under attack in the disciplinary committees of the Northern Provinces Legal Practice Council and in the Justice Portfolio Committee. What I'm going to do when I'm finished speaking to you and your viewers this morning is go to the local police station and lay a charge of perjury and defeating the ends of justice against the public protector, because her conduct and certainly the way that she has been in denial of her criminality is not serving the public interest in South Africa in any way. It is fueling a lot of divisiveness that is based not on facts but on politics, which is not the way that a public protector should work. I would hope that the Criminal Justice Administration realizes the urgency of the matter and deals with her in the criminal courts rapidly. We will then see whether Parliament is prepared to have a convicted perjurer as our public protector, and whether the Law Society or the Legal Practice Council gets on with its job of having her struck off the roll.
Advocate Hoffman, just a final question to you, and just very briefly. You've called for the public protector to be struck from the role of advocates. How far is that process?
The matter was discussed Friday before last by the Legal Practice Council and referred by it to the Disciplinary Committee having jurisdiction. I have heard nothing from that Disciplinary Committee, but I imagine they will be writing to the Public Protector and saying to her, well, what do you say? The highest court in the land has described you as a person who lies under oath in court. What are we meant to be doing with you? We cannot possibly have officers of the court who lie on oath and seek to mislead the court. That is absolutely intolerable in any country in which the rule of law is in place. And I'm sure that the Disciplinary Committee understands that and is treating the matter as one of urgency, given the role of the public protector. She's meant to be out there protecting the public, but at the moment, all she does is protect herself because she is on the receiving end of so much adverse finding by the Constitutional Court.
Advocate, thank you very much. Thank you very much for your time, Advocate Paul Hoffman.